Once again, we are back with a vibrant topic and at the right moment, nuances of Form DPT-3. I know everyone is going to face some or other issue. So this platform for discussion and, questioning our panelists like anything and take maximum advantage of their experience and knowledge. Mr. Manoj and Ms. Geetha, the participant will be asking you the question. All the participants, please put your questions as usual in chat box. The question will be taken parallelly, okay? But please stick to the topic only, all the questions. And welcome all, let's start the presentation. And before that, I will welcome formally our panelists, Mr. Manoj Singh, Bisht, and Ms. Geetha Shashidhar. Mr. Manoj Singh, Bisht, is a senior legal counsel and head of corporate secretarial South Asia. And Ms. Geetha Shashidhar is a company secretary of Ramkrishna Hospitals Private Limited. Welcome you both for your time. Thanks for your time. As regards brief introduction of Mr. Manoj Singh Bisht, Mr. Manoj Singh Bisht is a fellow member of ICSI and qualified lawyer. Presently, he is working as a senior legal counsel and head of corporate secretarial South Asia. Racket Banser Group is a leading FMCG company having products like Dettol, Harpic, Lysol, etc. He is well known for his interpretational skills and dynamic and out-of-box solution to complex transactional and legal issues. He is an expert in the field of corporate law, labor law, corporate compliance management, FEMA, security market, and others. Mr. Bisht has been speaker in several conferences and seminars organized by ICSI, ICAI, CII, PhD Chamber of Commerce and Industry, IIPF, and others. Welcome, Mr. Manoj. Thanks for your time. Our another panelist, Ms. Geetha Shashidhar. Ms. Geetha Shashidhar is a law graduate having masters in economics. She is member of ICSI and she started her initial career as a company secretary, compliance officer in Continental Coffee Limited, a listed company based at Hyderabad, and subsequently worked with various companies as company secretary along with other positions. She is currently serving as a company secretary for Ramkrishna Hospitals Private Limited and having experience in VC funding, restructure of companies, and other secretarial matters. Welcome, Ms. Geetha. We have with us our own Mr. Bala, who don't need introduction, and all our other participants. Today's presentation will be made by Mr. Niket Thakkar, and I'll request Mr. Manoj and Ms. Geetha to say a few words on the topic nuances of Form DPT-3. Then Mr. Bala, and then Niket, you can start your presentation. So over to Mr. Manoj. Thank you.
First of all, thank you very much for giving me this opportunity to discuss a very important topic, DPT-3. If you recall, when this particular rule came into being, a lot of discussions were carried on around what does really particulars of transaction mean. But ultimately, MCA clarified that you need to provide basically balance as at 31st March. And therefore, a lot of discussion around, aging, etc. was, kept aside. But now, recently, they have, last year, they have amended the rules, and now they are looking at aging, not only for loans in particular, but any and every amount received in the category of deposits, which really makes it a very complex, set of compliances, because now you have to provide aging for anything and everything. That is what I understand, insofar as the V3 system is also concerned. Number two, one of the basic aspect of these deposit rules, and what is that which Section 73 wants to achieve, is controlling the framework around receipt of deposits from public. That is the major intention. But at the end of the day, it is also receipt of deposit from public directly or indirectly, or wherever there is a public stake at large involved. Now, you will see a lot of transactions which are exempted, which may become deemed deposit, etc., etc. Ultimately, all of it is done for the purpose of ensuring that at the end of the tunnel, if there is any public stake involved, that needs to be tapped and ensured that those members of the public at large are not at loss. I think that is the objective of Section 73 per se. Some of the flexibilities under 73 for receiving deposit from members and all those things are provided, but the real issue, the core issue remains that what happens to the exempted deposits once you breach those norms, right? So today in this discussion at relevant time, we will also discuss those aspects of the deposit rules, what it intends to serve, and how do we need to basically deal with the definition of deposit at first stage, then go to the deposit exemptions, and then also see the carve-outs made within the definition, exempted deposit definition, and also importantly see what happens to exempted deposits once these breach the norm. I think that should be the focus. And insofar as reporting is concerned, I think Geetha will contribute greatly, because she knows in and out of the form how it works. But there has to be some discussion around how opening balance will come, what will you add for the year, whether it should match with the last year number, and what if it doesn't match. So all those we will try to cover in this discussion for the for better outcome out of this well thought of session today. Thank you.
Thank you.
Over to Geetha,
please.
Good morning, all. It is my immense pleasure to share my thoughts here in this great platform. And thank you, Mehta and Mehta, for this opportunity. I'm echoing the view of Mr. Manoj, because actually without money inflow, no business can run, and without that money, the promoter cannot arrange all the money which is required to the business. At the same time, they may cannot repay that money due to various reasons. One is that actually it is a genuine failure of the business, or else of intent of fraud to not to repayment, or else the promoters or management wanted to inflow that money into the system itself. Various reasons they may not pay back that money. All the reasons, whatever the reasons, actually end of the day, who has paid that money is the loser if it is not repaid to them. So government is very curious, or else very studious in regulating and restricting these kind of inflow of the money into the company. So that's why what they have done is, actually, first of all, they have restricted only public deposits. Now they brought all other kind of money inflow, because that's why the word used in the definition itself, any other manner, the money received any other manner. That's why they have used that word. So that they want to regulate those things also. At the same time, periodically, they want to know actually the kind of compliances, whether corporate is following these provisions and the various provisions put under Chapter 5 and other relevant provisions, whether they are following or not. That also the government want to monitor. So that's why they have introduced, or else I can say extended that filing of DPT-3, applicability of filing of DPT-3 to even exempted deposits also from 10/20/19. At the same time, this is actually need of the hour to discuss about the deposits as well as how the filings are going on. And my one caution word is actually don't try to care when you are reporting the figures. Better start caring when you entering into those transactions itself. Okay, maybe that is because once you see the penalty provisions, you may understand actually what is the significance of looking at each transactions while entering into. Okay, maybe this note you can start off this. We will do the analysis of DPT-3. Where we can, have more focus while reporting, or else while do the transactions. Thank you.
Thank you, Ms. Geetha. Rightly said, be careful while entering transaction and not while reporting. Very well said. And with this, Mr. Bala, just 1 minute and then we'll start the presentation.
Good morning to all of you. I have an immense pleasure to welcoming you all for this important topic. If you look at the participant today, it is already 300 in the beginning. So that itself shows what is the importance of this particular topic. All said and done, companies want to promote the greater corporate governance within the organizations. They want to have the greater accountability, and they also want to have the transparency. That is at the first. And the second thing is, as Manoj just puts it very clearly, it is the public. It is not only a public, it is actually public, creditors, everybody. Whosoever is there, the regulator want to actually protect. That is the whole purpose. Although we are talking about the return of deposit, it is not only the simple deposit in terms of what we actually think. It covers n number of money, whatever the form it is received. Let it be a borrowing, let it be a loan, let it be the money, the mature deposit, which is not claimed, which is lying with the company. All this sort of things they have actually covered. In fact, when the regulation came, as Manoj puts it very simply, discussion, it is not only a discussion, there were a lot of chaos. There were a lot of things, what is to be included, what is not to be included, clarification, things, etc. And coupled with that, again, there's a certification process is also involved. That means there's a great amount of the applications of mind by the certifying professional need to be applied into, whether correctly reporting it there, correctly recorded it there, all the things are all there in intricacies. And not only that, at the same time, they also wanted to protect the startup companies for which they are given certain privileges, etc., extending time period, etc., and other things as well. And although it talks overall, there is an exemption. Again, when we come to the exemption, there are again particular exemption within the exemptions. That is what Manoj was actually telling. Certain exemptions which are actually called out, etc., and all this thing. If the money is actually received for the supply of the goods, if the supply of the goods is to be made within about 365 days, then it is coming under the exempted deposit. But if it is exceeding 365 what days, how we are going to talk about it? These are the various intricacies which are there, as it appears to be. It is not just simply a filing of the form. It is right from the transaction, from the base itself, it needs to be looked into. It should be correctly recorded. And again, now the opening balance, aging 1 to 3, 1 to up to 1 year, 1 year to 3 years, 3 years and above. This all shows what happened to the money, whether corporate is involved in any sort of the malpractices, or money is actually protected for the depositor who actually put the money. All the things are all regulator concern. That is what it is. Today's topic is definitely going to be much interesting. As usual, as we go along, please put up your questions in the chat box. We will take simultaneously question as we go along. We'll have the most of the answers. I am very happy. These two prominent faculties who are there, they are well versed in the subject. They will be sharing a lot of practical experience, which will be immense benefit to all of us.
Thank you.
Over to Niket.
Yeah, the questions has already started. So, but we will start the presentation, and parallelly, when relevant, panelists, you can take it. And Mr. Niket, who is the Assistant Manager, Mehta Mehta. Niket, you can start sharing the screen and start the presentation, please.
Thank you, and good morning, all of you. I'm just sharing my screen. Is my screen is able to see?
Yeah, very
you
much.
can start.
So while we are thinking about the topic, firstly, we need to know about what is the deposit. Deposit nothing about but any amount received in kind of money by way of deposit or loan or in any other form by a company. It is a deposit, but it does not include such categories of amount as prescribed by the CG. It means central government in consultation with the RBI. This topic is totally covered under 3 sections. The first one is the chapter 5 of the Companies Act 2013, section 73 to 76A, and the third one is the Companies Acceptance of Deposits Rules 2014. this topic is when you are thinking about this, so this section is not applicable to the following companies. The first one is banking company, NBFC company, and housing finance company. Who are the eligible companies who can get the deposits and accept the money from the public? It is a public company who can accept the deposits from the public, who have a net worth of the minimum 100 crore and the turnover of more than 500 crore. They can accept the deposits. The consent of members by way of special resolution, it is required, and the same needs to be filed with the ROC within the 30 days from the passing of special resolution. However, if the deposits is within the limit of section 181C, then the ordinary resolution will be sufficient. That is the paid-up share capital, free reserve, and surplus. Bala sir or Manoj sir, anything required to discuss?
So I think one of the main object of definition of deposit is to cover anything and everything which is refundable in nature, because it uses the word deposit, then it goes on to use the word loan, and then it goes on to use the word any other amount received in any other form. So basically, the intention is to apply the rule of aegis generis and say that anything and everything which is in the nature of a deposit or a loan has to be treated as a deposit for the purposes of this section 2, read with section rule 2 of this Companies Act.
Absolutely right, Manoj, because it is a public money which is lying with the company. They are interested in accountability, because the money is at the end of the day is refundable. It cannot lie with the company lifelong for one reason or other. Yeah.
Yes, but the important aspect here is, insofar as definition of deposit concerned, deposit as a word, loan as a word, is understood in business as something which is given for interest, with or without interest, also sometimes in relations where you don't really charge interest. But there is some form of refundability attached to it. But if you see any other form, it is so wide, and because of the exemptions now provided by the central government in consultation with RBI, okay, who are reasonable and are objective about what has to be covered, what not has to be covered. And the exemption list goes on to cover all kinds of transactions which you carry out in day-to-day business. So therefore, now if you holistically read section 2 with section rule 2, you would come to a conclusion that any other form effectively covers any money which is ultimately refundable during reasonable period of time. And in exemptions, they have now carved out those timelines also. What is that we will treat as not deposit? After that, the presumption of being a deposit will trigger. We'll come to that also when we discuss exemptions. But once the deemed deposit concept triggers and you are basically in breach of that limit, the presumption that it is deposit is well established. Now, what do you do? Whether you rebut that presumption by way of documentary evidence, what do you do? Basically, if it is a genuine business transaction, which is defendable, which can be corroborated with documentary evidences, can you really show that even though these are not now exempted, they will still be deemed deposit just because they have breached those timelines, yet there is a documentary evidence, whatever set of documents you have, which definitely proves that it was never a deposit or a loan or of that nature or was refundable. Today you take an advance which is to be written off. If you don't, if some, both parties have condition precedent. If you don't give them, for example, some declarations to be made on a particular package of products, if you don't give it for 1 year, they have deployed resources, they will be eligible to write off that amount pursuant to the terms of the purchase order or an agreement. So all those things will come to haunt even the authorities as to how do they treat a breach of deemed deposit as a deposit when there is an evidence to show that it was a genuine business transaction, because genuine business transaction cannot be prohibited under Article 19 also of the Constitution. Right to business profession is sacrosanct with business. So these are some nagging issues. And therefore, genuine business transactions have to be tested again against the definition of deposit and read with rules, because ultimately this is not the primary rule or provision. Primary provision is section 73, invitation of deposits from public. So it will be tested against that. We'll discuss further. I don't want to say more now because there is a lot of discussion which has to happen on the definition. That time we'll take it up in detail. But for now, that is the thing. The second thing is, insofar as definition is concerned, we have to be careful about how we treat free reserves and what we include in free reserves, whether surplus in profit and loss account needs to be included, etc. You have to be cautious because this provision is not in your favor. It is in the favor of the depositor. And therefore, you need to apply strict interpretation and refer to the definition in context of the, whatever is in the interest of the public and not in the interest of the company. Thank you.
So maybe one exclusion, I mean, the 2-3 transactions like exclusion we will take from whatever Manoj has mentioned, maybe central government, state government, whatever they are going to fund as a repayment kind of thing on behalf of the corporates. So that is for a company or corporate, that may not be the repayment mode. So that's why those things are little exclusions, that's all.
Yes,
Thank you.
Niket, go ahead.
Okay, sir. So while company is accepting from the deposit from the member, it is covered under section 73(2). Section 73(2) enables the company from accepting the deposits from its member, subject to passing an ordinary resolution at the general meeting, and the company has to fulfillment the following conditions, which I have mentioned. The first one is the issuance of the circular to its member in form of DPT-1. The second one is filing of DPT-1 with the ROC within 30 days before issue of circulars to the member. The third one is depositing each year at least 20% of deposit amount maturing during next financial year in DRR account by 30th of the April every year. The fourth one is the certification from auditor that company has not defaulted in repayment of the deposit or interest payment, and if there is any default in repayment of deposits or interest repayment, then 5 years cooling period from the date of making good the default is required. Then the fifth one is security. The company has to create the security, if any, for the due repayment of the principal amount and interest thereon within the 30 days. Otherwise, it will be treated as an unsecured, and the same needs to be quoted on every circular from the advertisement of inviting deposits. Here, the MCA has clause D has just removed, and it is omitted, which was stipulated that company has to take the deposit insurance, and it is done away by the Companies Amendment Act 2017, which was effective from the July 5, 2018. So while company is accepting the deposits, here I have mentioned some, as per rule 3, the maximum limit the company can accept the deposits by way of amount in by from member and public. If it is a non-government and eligible public company, that we have already discussed the definition of eligible public company earlier before this slide. If it is an eligible public company, then company can accept from the members up to the maximum 10% of the paid up share capital reserves and free reserves and surplus account, if any. And if the eligible company wants to accept the deposits, then company can accept the deposits from public maximum up to 25% of paid up share capital, free reserves and surplus. And while we are discussing this, and if it is a eligible government company, they can accept from members as well as public, but up to the 35% of the paid up share capital, free reserves and surplus account. So shall I move?
Yeah, move on.
So while company is issuing the deposits, the government has prescribed the tenure of the deposits and the rate of interest also be covered. The company cannot accept the deposits which is repayable on demand or for a period of not less than 6 months, provided that the deposits may be accepted or renewed for less than 6 months for a working capital purpose or short-term fund requirement up to the 10% of paid-up share capital, free reserve and surplus account, subject to repayment of period shall not be earlier than 3 months from the date of acceptance of renewal, as the case may be. Here we have already discussed that the company cannot accept the deposits which is repayable on demand and less than not 6 months. The government has also covered that the deposits shall not be more than 36 months. If for acceptance and renewable, the interest rate shall not be exceed the maximum rate of interest as prescribed by RBI for acceptance of deposits by NBFC. So what will be the premature repayment? If the depositor is asking for the premature repayment and renewable of deposits, then the provisions of these are here I have mentioned some. So on request of the depositor, deposits may be repaid after expiry of 6 months. However, the interest rate payable on such deposits shall be reduced by 1% from the rate fixed by the company or at an original rate. And in the following cases, the above mentioned provisions will not be applicable if the repayment is made solely for the purpose of, first one is complying with the provision of Rule 3, but obviously it is not required. The second one is providing war risk or related benefits to the personnel of naval, military or air forces or their families under emergency period declared under the article of 352 of the Constitution. Company has accepted the deposits, but now it is about to depositor is requesting to renew of the deposits. Now they can do where company permits to depositor to renew the deposit before expiry of period for availing the higher rate of interest, then the company shall pay a higher rate of interest if such deposit is renewed for a period of higher than the unexpired period of the deposits, and it is will be in the accordance with the provisions. So what is the procedure of acceptance of deposits? The company needs to call a board meeting, needs to pass a board resolution as and when required for acceptance of deposits. The company has also required to call a general meeting. While conducting the board meeting, the company needs to pass the board resolution and approve the EGM notice, pass the necessary resolution in general meeting. The next one is after passing the resolution in general meeting, company needs to file the MGT 14 within 30 days after filing of MGT 14 and before taking the credit rating from the credit rating agencies. The company needs to appoint a deposit trustee and the execution of the trust deed in form DPT-3. The DPT-3 form DPT-2 already format is provided by the government. After obtaining the credit rating from the credit rating agency, the company needs to file the form DPT-1 for creation of security, and the same form needs to be filed with the ROC within 30 days before issue of circular in DPT-1. After filing of CHG-1, the company can issue the circulars to the members in English and vernacular newspaper. After that, company needs to issue the deposit receipts to the depositors.
Just a minute, Niket. Just
Sure.
for everyone information, we today, since there are many questions, to keep continuity in presentation and let the presentation be over and the panelist comment be over, then we'll take questions. So many questions may be answered during session only. At the end only, all questions we will take. Okay, thank you. Yeah, Niket, go ahead.
Yeah. So company can issue the deposit receipt to the depositor within 21 days from the receipt of money. The company needs to make the necessary entries in the register of deposit within the 7 days after the issue of the deposits receipt. what will be the company needs to enter in the register of deposits? It is mentioned in the rule 14 of the company's deposit acceptance rules 2014. It is already covered all, as you are aware, the register of deposits shall be maintained for at least 8 years, and it should be maintained at the registered office of the company separately, which shall contain the following details. The first one is name, full name, address of the depositor, PAN card number of the depositors, particulars of guardian in case of it is if the depositor holder is a minor. The third one is the particulars of the nominee. Fourth one is the deposit receipt number. Fifth one is the date and amount of each deposits. The sixth one is duration of the deposits and date on which deposit is repayable. The seventh one is the rate of interest. Eighth one is mandate and instruction for payment of interest and for non-deduction of the TDS, if any. The next one is date on which the payment of interest shall be made. The next one is details of deposits, insurance done away. It is already, I just told you that earlier the MCA with new amendment act of the Companies Act, they have done away. The next one is particulars of the security or charge created for the repayment, which we have to file the form CSG1 within the 30 days after the creation of security, after the creation of charge, and any other relevant particulars mentioned by the board of directors and board of directors of the company. So, as we have discussed that company needs to appoint a deposit trustee and the company needs to create a deposit deed of trust deed. Okay. So, who will be the person are eligible to become a deposit trustee? The first one is the director or key manager personnel or officer or employee of the company, or it is a holding a subsidiary or associate depositor in the company. The second one is indebted to the company, or it is a subsidiary, or it is a holding company, or associate company, or a subsidiary of such holding company. The third one is has any material pecuniary relationship with the company. Fourth one is has entered into any guarantee agreement in respect of principal debt secured by the depositor or interest. Fifth one is related to any person specified in clause A. Then he can become a depositor trustee. Once the circular or advertisement is issued, no trustee shall be removed except with the unanimous resolution passed by the board at the board meeting, provided if the company has an independent director on the board, at least one independent director should be present in the end. Consent is required for removing the deposit trustee. Shall I move, sir? Anyone?
If panelists want, they will speak. You can move ahead.
Okay, ma'am. So, exemption to private companies, clause A to E of section 73, clause 2 shall not apply to the following private limited companies. The company which has accepted the deposits from its members, does not exceed to 100% of paid up share capital, free reserve, and surplus account. The second one is a private limited company and who is a startup company for 5 years from the date of it is incorporation. The third one is fulfills the following condition. The first one is which is not an associate or subsidiary of the another company. Second one is if the borrowings from the banks or financial institution or body corporates is less than twice of its paid up share capital or 50 crore, whichever is less. And the third one is not defaulted in the repayment of such borrowing subsisting at the time of accepting deposits.
Can we take a questions, Mr. Bala? You're there?
No, I think Atul, what I have discussed, because there are a variety of questions, and if we cover, it will break in between.
Because she says there are many questions which have been raised actually being discussed in the slides.
Yeah.
Okay. So she says it's preferable that we take at the end of the section so that many of the questions would have been answered by her.
Yeah, by that time only.
Okay.
So
If it is a if it is relevant to that slides, we can.
Yeah. I think none of the questions
Yeah.
so far have been relevant for the eligible company portion and deposit.
Yeah.
Okay, ठीक है.
It is
Okay.
with the relevant to form only majority is there.
Most of the things are all clarification. The forms only has come
Yeah.
on this. Yeah.
So MC has just introduced a new form on version 3 portal. There are basically purpose of the form of DPT-3 are totally 4. The first one
Just
is
a minute. So there is a question from Mr. Sachin More. Private company accepted funds from members of the company as per complying the 3 conditions. How to report these funds in DPT-3 as no any filed available for reporting funds received from members. Geetha, would you want to take that up?
Yes, sir. It is nothing but a return of deposit, because if you see that 100% whatever is available, taken from the members, it is nowhere, it is there in the 18 transactions covered under exempted deposits. It is nothing but a return of deposit. You have to comply whatever, fields it is required to fill for return of deposit. But due to that, we are exempted from A to E, 73 subsection 1, class A to E or exempted from the compliance. Remaining compliance we have to do.
So it is basically still a deposit and you have to report it as a deposit.
Correct.
Reporting is required actually, but only those exemptions which are actually called out will be applicable.
Okay.
Yeah, Niket, go on.
Yes, sir. The purpose of the form is totally divided into 4 parts. The first one is return of deposits. As we are this point is already covered, and we almost professionals are aware about this return of deposits. Since 2014, we are filing this form. The second one and most important is the particular transaction by a company not considered as a deposit as per Rule 2(1)(c) of the Companies Act, Companies Acceptance of Deposits, Rule 2024. The third one is return of deposits and particulars of transaction by a company to be not considered as a deposit. And the fourth one is a one-time return. One-time return is for disclosure of details, outstanding money or loan received by a company, but not considered as a deposits in terms of Rule 2(1)(c) of the Companies Acceptance Rules 2014. And the company, while reporting these kind of deposits to the MCA, the company needs to take the amounts from the April 1, 2014 to 31st March 2019.
Just a minute, Niket.
Do we have,
yeah.
here somebody is asking, do we have to file DPT-3 if there is an advance receipt from the customer for sale of goods, which is appropriated within 365 days?
Sir, we'll discuss this when we discuss exemptions.
Okay.
Come to
That's
this.
why, I thought that the question will take, if panelists want to take any relevant or comment, that will take. Very complex question will come then. It will be difficult.
Okay.
Yeah.
Here on this slide, actually, fourth one is almost redundant. Okay, we are not using anymore for that. Return of deposit, just now previous question what I have answered. So you can choose the if you already also have exempted deposits in that reporting. I mean, when a private company receiving amount from members, and also you have other transactions which are falling under 1 to 18 transaction of exempted deposits, then you can choose second one. And both the amount you can report under that call, that radio button. Okay, thank you.
Correct.
Thank you. Yeah.
So the main purpose of the form and to clear the doubts on exempted deposits, it is covered under Rule 2(1)(c), and here are the first one is any amount received by the company from central government, state government, local authority or statutory authority, then it will be considered as a exempted deposits. Second one is any amount received from the foreign person or foreign source subject to FEMA regulation 1999. The third one is loan or facility from the bank or public financial institution or RFI or insurance company. The fourth one is amount any received by the company against commercial paper issued by the company, then it will be considered as exempted deposits. Any amount received by the company, then it will be considered as a exempted deposit.
So one of the important thing about any amount received from central government or state government, etc., is the subsidy part of it. If you see, the entire concept of deposit is a balance sheet concept. But most of these subsidies will go and sit in your profit and loss account. Correct? Now, if you say that these are exempted deposit, whether it is right in facts of the case, these subsidies which are given to you at one point in time, not refundable based on purpose and object of the project which you have taken up. Whether these are really exempted deposits also, leave apart deposit. So, in my view, these subsidies, etc., which are received from the government sitting in your profit and loss account, not refundable in nature, are not deposit nor exempted deposits. These are not reportable in my view. If anyone wants to add, please do add.
Geetha, your view?
Same, ma'am, actually, as exactly Manoj said, it is not reportable under this thing. But why they have covered there is, they have used that concept of repayment. On behalf of the company, the central government or state government is repaying to the financial institution or the thing. Broadly, if they consider that thing, actually, it is a repayment purpose. For corporate purpose, yeah, what he said exactly, even I am in the view of not to report anything such sort of things.
So if it is a subsidy, not refundable, etc.,
by corporate,
as long as it is
not
compliant
reported.
with, as long as it is compliant with all the, if you even see, they have not even said that you need to comply with the terms and conditions of subsidy letter. Right? It simply says any amount received from central government, etc. And then it goes on to repayment and other aspects of it. But strictly speaking, on any amount received from central government or state government, that will not include subsidies because they are the PL account items. They are not refundable in ordinary course. And there are other ways of seeking cancellations and all those aspects which are generally covered in government documentation for subsidy. That recourse government can always take. So that is not intended to be covered here. Right, so just wanted to highlight.
Yeah, you are absolutely right, Manoj. You are absolutely correct. Thank you.
Yeah. Okay. Niket, next.
Okay, ma'am. So the next one is any amount received from the subscription towards securities, including advance call also, it will not be considered as exempted. It will be considered as exempted deposits. The next one is any amount received from the
just a minute. So if you see this, any amount received, and this is very important aspect, any amount received and held, mark the words received and held, pursuant to an offer made in accordance with the provisions of this act towards subscription to any securities, including share application money or advance towards allotment. So it now dissects, or advance towards allotment of securities pending allotment, so long as such amount is appropriated only against the amount due on allotment of the securities applied for. So one most important aspect of this is amount must be received, it must be held, and held for the purpose of allotment. Now let us go to the explanation. We would want to discuss some of the provisions in detail. So let's dissect this. For the purpose of this subclause, it is hereby clarified, without prejudice to any other liability or action under 42 or elsewhere, if the securities for which application money or advance for such security was received cannot be allotted within 60 days from the date of receipt of the application money or advance for such securities, and such application money or advance is not refunded to the subscribers within 15 days from the date of completion of 60 days, such amount shall be treated as a deposit under these rules, not a deemed deposit, but deposit under these rules. Okay, you will see under this rule 2 that somewhere they've used the word deemed deposit, somewhere they've used the word deposit. Because generally, if allotment is not happening, the money is refundable. It is a fit case of being a deposit, nothing else. Now, one of the aspects is conversion of loan. I have been saying that you have to be very, very cautious about going for a conversion of a genuine debt, not even a loan, but a debt. Now, when you go for a conversion of loan and suddenly in between promoter and the incoming intended shareholder get into a dispute on the conversion which is of a loan which is repayable on demand, etc., etc., what happens to that amount once offer is given and acceptance is received, that treat my amount of XYZ in your accounts as amount paid towards allotment or towards share application money. And if you cancel that allotment, you don't proceed with allotment, because it is a concept of invitation, offer, acceptance gets completed in terms of the Contract Act on the date of allotment and filing of pass 3. And that is how this entire transaction is also controlled under the Companies Act. Now, if you don't proceed with that, allotment is cancelled. What will be the fate of that loan? Whether it will be treated now, it will automatically be refundable pursuant to the deposit rules within 15 days. That's an argument. As a shareholder, I may want to take that argument. But is it really an amount? And I've been thinking about it for quite some time, whether it is really an amount which should be repayable within 15 days, because it is now the allotment has not been proceeded with. The parties are in dispute. But when the amount was received, pursuant to the terms of the arrangement from that shareholder, what was the nature of the amount is relevant, assuming that the shareholder is somebody who is also eligible to give that money pursuant to the rules at that point, relevant point in time. Whether this rule can really be invoked, and can he claim that it is a deposit and go to chapter 5? That's a very important discussion. I would encourage, if Geetha wants to contribute on this, or if any one of you wants to contribute on this, so that we discuss this further, how this will pan out.
Yeah, Ms. Geetha.
Normally, actually, the two coin words, that is received and held. Okay. See, since from beginning, the money as received as a loan for the purpose of converting into securities in a future date. Okay, so that money is anyway lying. Anyway, we are considering that as a loan. Even when it start taking up, in the color of subscription money, when we start the process of converting into allotment, even at that stage, if it is not converted into any securities, even then, actually, I am in the opinion of that I can continue that money as a loan if the term of that agreement says and the period is still left out. Okay, so I am in that opinion. Anyway, I'll
just take this further. I have not yet completed also, to be very honest. Now we go to section 42 again. When it comes to convenience, we say that amount received by way of adjustment of loan does not need a separate bank account. Do we agree on that, everyone? Because the amount is not really received, it is adjusted. So there is no requirement of a separate account for keeping that loan amount there. You cannot park the funds if you don't have the funds. The entire objective of conversion of a genuine debt is to adjust, because you are in need of payment. Otherwise, you would have taken from somebody else and paid off that loan. Or you would have taken from him and then again returned effectively. So this conversion is a well understood principle. Conversion of a genuine debt is not an issue. You don't create a separate bank account, but you do make an entry. As soon as amount is received against the invitation you made, you make an entry in your books. What entry does the company carry out in its books? Does the company effectively park that money as money received against, share application money received against section 42 pass 4, whatever. Once you make that entry, that money doesn't sit in the loan account of Mr. X. Now the nature of the money is changed, admittedly by you. Now tomorrow you want to take benefit of rules, deposit rules, which are in the favor of the public. Let us also understand the beneficial legislation. This, insofar as these rules are concerned, is towards public. So if you go to NCLT or elsewhere, what is that which will happen on day one? So once you receive the money, first and foremost thing is, what will be the adjustment you will make in your books, or you will keep it pending for adjustment. You will not make any entry. You will keep it in advance. What will you do? Effectively, is anything on table, and therefore facts are so relevant in deposit rules or elsewhere under the Companies Act. If the amount is moved to a ledger, in your ledger to advance received against share application money towards allotment, then you will be covered by those rules, deposit rules, and you may get into 73, 76 A, etc. because you yourself have admittedly done that transaction. Right? So we have to be very careful how we structure the transaction for conversion of a genuine debt, so that these difficulties are not, witnessed. And you have to be very careful about these kind of transactions. You cannot take benefit of Section 42 separate bank account related principles and then, take a different position under the rules, the deposit rules. Consistency, structuring, better planning, better alignment with shareholders, stakeholders, and better and importantly, accurate accounting treatment at the right time. These are very important aspects of any allotment you are doing, keeping in mind deposit rules.
Excellent discussion and point, Mr. Manoj. It was very interesting how the color changes the moment it is converted from loan to equity thing, because entire transaction from debt to equity position they are taking. So that's
just to add one point which I missed. In fact, the deposit rule says that the amount shall not be adjustment of the amount for any other purpose shall not be treated as refund. So once you color it with application money, you cannot really go back to adjusting as a loan or whatever. But he will have a benefit of applying for both rules of treating it as a loan or as a share application money, and he can do foreign shopping. He can very well do foreign shopping. He can go for civil remedies. He can go for criminal remedies. So you are opening a Pandora box for yourself when you don't carefully do conversion.
Right.
Manoj, again, this brings to the point, because normally we keep hearing from the company secretary when they talk about the financial statements, accounts, etc. They are actually keeping a distance away. When you are talking here, it actually gives you more and more important. We need to get involved right from the transaction stage itself. That shows the company's secretary's greater role in getting accountants with the finance people working in team.
Absolutely right, sir. Absolutely right.
Because the transaction happened, he is not aware. When the return is coming, he is aware. Then he is nowhere.
Right.
When you are talking about the complaint, as a complaints officer, he will be held responsible. So we can't keep distancing away from this thing. That's what the point it comes out now clearly. Yeah.
Yeah. Thanks. Interesting discussion. Yeah, please go ahead.
Okay. The next one is the any amount received by the company from director or relative of director of private limited company. This will be considered as exempted deposit, and the company has to.
So Geetha may want to contribute here. And Geetha, there is one question around HUF being a relative or not. You need to also include that in your discussion, if at all possible.
Yeah. Director and director relative, it is applicable for private limited company, and only director, it is for public company. And HUF actually, in a broad view, if you see, if all the members of that HUF, they are the part of the company, or else they are acting as a directors of the company, then receiving from HUF is exempted deposit. But if it is only the Karta is a director on this one, or else is a relative of the director, so then it is not considered as exempted deposit, as per my opinion.
Now, the important issue here is when we say director or relative, I know for a fact that a lot of people want to structure the transaction by way of contrivance. by appointing somebody, taking the loan, then removing him the next day. All these things don't work under this kind of things. However, it will be seen very differently from a corporate governance point of view. But if that particular person who was appointed as a director is able to bring to table things which demonstrate that all of it, the entire transaction was done in bad faith, right? In fact, good faith without negligence is fine. In fact, General Clauses Act, if you see the definition of good faith, negligence does not amount to bad faith. That's fine. Not giving a declaration, all those things, okay, it's a negligence, or you can call it in day-to-day business affairs. How small companies work. That's a separate issue. But when it comes to appointment, taking loan, resignation, etc., if documents come to the fore and establish that all of it was contrivance, and it was effectively to breach this law, and the person who was appointed as director also was not aware of these nuances, and he was able to prove that all of it was a contrivance and not a structuring per se, which is permissible, or a planning per se, then also they will get the benefit. What I'm trying to highlight here in this call is we need to be very, very, we need to be on top of the facts. Then this law comes into play. If you are not on top of the facts and you are just doing, a broad review of these kind of provisions without learning how to read and dissect the facts, you will not be able to do well on the subject matter. That is one. The second important aspect is the declaration part of it. The objective is that you declare, and your declaration must be accurate. Declaration should be not only to the best of your knowledge, but accurate. If the declaration goes wrong, then also it becomes a deemed deposit, except for other exemptions if there are available. And sometimes what will happen is even the auditor may want to get into that zone where they want to seek further details. What kind of and what level of details is dependent on each auditor, etc. But director has to ensure that he is able to prove that, because it's very difficult to prove that you have taken loan from a bank and you have not given it specifically for this purpose. So your balance sheet, or as on the date of declaration, should demonstrate that you are actually paying this money out of your own funds, and the company should actually take that whatever loan and funding related table can be formed within that declaration, where it is demonstrated that he is giving it out of his own funds. It will also help you whenever there is an ROC or anyone's inspection, etc., because director will be, say for example, that you had appointed somebody as director in 2015, he gave loan in 2015, he left in 2020 or 22, loan is repaid, but when inspection happens, they may want to see how and why this money was received and how it was, how do you prove that it is out of own funds. Let us not be expecting that they will not ask those questions just because it is not written here. So some basic fundamental details needs to be there in that declaration to make it more robust and more clear for you also to keep in your records.
You mean that actually to the extent of checking bank account details, I mean bank statements, we should go back and check.
Director need to do reasonable assurance activity at his end.
Oh.
Provide a basic declaration with some level of numbers or some level of comfort, which is self-explanatory for you. You don't need bank statement, etc. from them. But what is that he is placing reliance on is also important, because sometimes authorities may seek those documents from you, and the director, once he leaves the company, he may not cooperate with you.
But normally, Manoj, we all go by taking a declaration from the director. We believe in the trust and belief. We go by that. We don't go beyond questioning the declaration and source, etc.
But if the declaration goes wrong, you are at the receiving end. not only from a deposit repayment point of view, but otherwise also under the deposit provisions, you are at the receiving end. So you would want to take care of all these parameters so that you are, because at the end of the tunnel, it is the company and the existing management. So records have to speak for itself. It cannot be just a one-line declaration. Then what is the use of having a setup of professionals who cannot really guide them? So there has to be some genuinity brought to the table as to the numbers, etc. Some level of detailing. Then just saying that it is out of my own funds. So we need to think about these things. How we can, for example, practicing companies like this, they deal with hundreds of clients. Right, you just take a declaration and then do basis that, and they will tomorrow say that you did not ask me for these things and therefore I did not give these things. I thought that it is in my bank account, therefore I am giving. What you communicate and what director understands is your client understands is also a problem. So once your format is such, which clarifies what are the thresholds, you will be able to better feel and give it to you. For example, 184 disclosure of interest. I'm just digressing from the topic. If you don't guide them on what has to be disclosed, how you can disclose body corporates, how you can disclose individual relationships, relatives list, etc., etc. Today, a 184 does not seek relatives list, but you may see list of relatives as well as companies where relatives are directors, etc., where there is an indirect interest, because 184, 1 is very, very wide. I'm not talking about 2. Even the exemption given under 194 is for contracts or arrangement, but not for disclosure. And disclosure is also linked to duties of director, which talks about conflict of interest. So if you don't guide them with a breakup of what all you expect them to disclose, they will not be able to disclose. So it has to come from our side that, this is the level of detailing which needs to happen there, or at least by way of a different letter, if not as part of the declaration. Somewhere it should be sought so that you are totally 100% accurate insofar as your facts of the case are concerned.
Okay. Yeah, Niket, go ahead.
The next one is any amount received by the company in way of secured bond issued by the company or debentures on that first charge or ranking pari passu has already been created. And the next one is company has issued the compulsory convertible debenture and the maturity period is up to 10 years. Then it will be considered as a exempted deposit. Any amount received by the company by way of issuing by issuing of non-convertible debentures, and it is issued by the listed company and it is an unsecured company, then it will be considered as a exempted deposits. So next one is secure deposits. Any amount received on a secure deposits from the employee which is bearing known interest, and the company can accept the amount up to maximum annual salary of that employee, then it will be considered as a exempted deposits.
One important point on employee is you need to also get into the details of what is an employer-employee relationship. Right? In a small setup, you also need to see whether it is really an employer-employee relationship. Just deducting PF is not the threshold. Right? Deduction of PF is also, there are limits, 15,000 and all those things. Somebody is directly hired at 30,000, etc. There is different ballgame altogether. Then on some of the, compliances under the labor law, there are requirements of meeting those thresholds. Till you don't meet those thresholds, you are not required to comply with those labor laws. So that per se, having PF, not having PF, etc. will not determine whether somebody is an employee or not. Right? So employer-employee relationship is relevant. And at some point in time, if you are saying that it is a security deposit and kept as a security deposit, then you need to have, you remember 185, right? How it pans out in context of loan to WTD, etc., MD, as part of genuine loan policy of the company. 186 also talks about it in a very subtle way. So somewhere the concept of employer-employee relationship will have to be tested against this clause to seek an exemption under this clause.
Right. Yeah, Niket.
So next one is any amount received by the company, which is pursuant to non-interest bearing, and it is in held in trust by the company, then it will be considered as exempted deposits. The next one is any amount received by the company, advances for the goods or services, which is
Just a minute.
appropriated in the 365 days, then it will be
So-
considered as a exempted deposits.
So there is one question from Mr. Anil Shah. Unsecured non-convertible debentures is part of deposit, but intercorporate deposit is exempted. If company has issued NCD to company, will it be exempted considering ICD? So I think this is where the entire issue revolves. And this has happened because of Form DPT-3. People are really confused. But you see what is that Rule 2 seeks to achieve. Rule 2 seeks to demonstrate to you that this is deposit, the definition, deposit, loan, or in any other form. And then it seeks to give you certain exemptions. Now, if you fall in any of the exemption, then you are eligible for this thing, benefit of this law, and you will be treated as exempted deposit. So ICD will effectively, because ICD is generally, NCD is generally a deposit in context of this, but since it is an intercorporate deposit, it will be reportable under any other amount received from any other, amount received from any other company, rather than being reported elsewhere. But to say that any amount received from any other company is reportable under DPT-3 is incorrect. First test for reporting under DPT-3 is amount is received as loan, deposit, or in any other form. I'll give you an example. You are sitting in a shop selling Whirlpool AC. Somebody comes, you raise an invoice, he gives you payment, takes his AC. That amount is, and that the person who is making payment is a company. You are also a company. Now, whether this amount is any amount received from any other company, yes, it is. But whether it is really needed to be part of deposit exemptions or deposit per se, because the threshold is deposit, loan, or any other amount. This is not a deposit. This is not a loan. This is not even an advance. This is a payment after issuance of invoice. Now, if amount was received as an advance, so you have to be careful. Sometimes what they do is they raise a pro forma invoice. You make an advance payment. Then they issue an invoice. Then they adjust against it. That amount is reportable or not? Answer is yes. So we have to be careful about how this is panning out. Not any and every amount received. The thresholds have to be met. It has to be a deposit or a loan and any other amount which is received in the nature of advance when we are talking about business, or which is adjustable after raising of invoice against that invoice. No fresh amounts will accrue. So that is to answer that particular question on the ICD.
Okay. Yeah.
Now, held in trust. Geetha, would you want to take this up, or I can take if you?
Yeah, continue, Manoj.
So in held in trust, a lot of company secretaries also have, LLP and company model where they have their private companies also where they provide non-attestation services, which is permissible also. Sometimes you may take, fees to be paid for stamp duty, all those things. Anything and everything which you have kept in your books as held in trust, right? And you are using it for those purposes. Those are not intended to be covered under the deposit definition, because those are very genuine business transactions. So effect of this entire, framework of exempted deposit is to ensure that business is not disrupted, but only genuine business transactions, right? The camouflage, the contrivance related, strategies will not work as long as it is a genuine business transaction, which they have, put down as a part of exemption. Those are not treated as deposit, even though by reading up, the definition of deposit in a very literal sense, they may be, but that is what they intend to do. But the first and foremost important point is this stamp duty and other things are non-interest bearing, right? So that you need to keep in mind. So not everything can be said to be held in trust.
Okay. So the next one is any amount received by the company for goods or services as appropriated in 365 days. And the next one is any amount received by the company.
Actually, this advance for goods and services appropriated in 365 days actually made so many companies to change their strategy of various schemes. Like for one of the example that in one of our client, they were into agri, dealing with the farmers, and they take advance for the supplying the seeds and fertilizers and all that. It is based on the season to season, and they used to keep the money and they used to give on credit and all that, and it was roll over because many times they don't come also. So certain deposit, actually they have to plan and change the scheme. Forget then also that the jewelry company who used to take every month some money, and at the end of the year or later on you can get it. They have made it 364 days so that they come within, don't come within this category of 365 days. It has a big implication of 365 days. Yeah, please go ahead.
Where Dipti ma'am told it's a jewelry company. So for example, Tanishq, it was earlier, it used to take like, 11 months or else 365 days deposit, but there also sometimes in a last minute, what was not claimed by any depositor. Okay. So those amounts lying, huge amount was lying with Tanishq, and they have changed the scheme itself, and they have, whatever A to E, the compliance is there, they made, and now actually they're properly under deposit rules, they are collecting the money. So like that, actually, so many jewelry companies have changed their, strategy and schemes under this deposit rules to not to cover under, default.
And honestly, RBI was keeping eye on this scheme. They were also trying to say that, because I had given the lecture to RBI, and they were deeply inquiring how it is not deposit, why we cannot treat it as a deposit, and they were, and then there's all clarity, and that's why all jewelry company now in parallel with the compliance. Yeah, Niket, please go ahead.
So, if company is getting any kind of advances against the immovable property, then it will be.
We need to discuss this more. So there are questions around it. Advance for the supply of good or provision of services. Okay. Provision of services and supply of goods.
Manoj, shall we take now, because there are more than 20 questions ahead we have left, or we will finish and at 12:40 we start. Huh? Because many questions are there, Manoj. See, and
I'm okay.
Otherwise,
I think we should take the questions. Yeah.
And then 12:40, Niket, you try to finish 12:45, because people are asking when you are starting the question, and we'll start the answering all the questions.
Yes, ma'am.
Starting, okay? Yeah.
Any amount received by the company as a security deposit for the performance of contract or performance of the services, any amount received under the long-term project, if any.
Panelists, you can comment on the slides, huh? Only questions we will not take. Please give your expert comment.
I'll just make one point on advance received for goods or services. If you see, it talks about matter pending before the court of law, legal proceedings before any court of law. It doesn't talk about arbitration. Okay, it doesn't talk about issues where mediation is happening, conciliation is going on. Only court is blessed with it. But I think arbitration would squarely fall under court proceedings because of the provisions out there. They have powers. They have powers of the court insofar as arbitration is concerned. That is one point.
Should we take the questions?
No. We are just going.
Just wanted to highlight that one particular important aspect.
Okay.
Any amount pertaining to received by the company for a future service which are going to be rendered by the company, and it will be up to, if the amount is up to the 5 years, then it will be considered as a exempted deposits. Any amount received by the company as an advance for the subscription towards the publication, and an amount pertaining to allowed by the secretarial regulator, then it will be considered as a exempted deposits. Any amount received by the company by promoter or their relative by way of unsecured loan in pursuance to the stipulation of any lending financial institution, any amount received from Nidhi company under section 406 of the Act, then it will be considered as an exempted deposits. The next one is any amount received by the way of cheat funds under stipulated under Cheat Fund Act 1982. The next one is any amount received under CIS, any amount received by venture capitalist, any amount received by AIF or mutual funds. And the next one is real estate investment trust or infrastructure investment trust. Then it will be considered as exempted deposits. The next one is any amount received by the company, startup company, by way of issuing the convertible notes, and the convertible notes are going to be converted in the equity shares or which is repayable by the company within the period of not exceeding 10 years, then it will be considered as the exempted deposits. So this one is the main thing which is introduced by the MCA in the new form. It is categorized the loan or amount received by the company. Then the company needs to report under this category and under these categories, and the company needs to bifurcate these amounts in aging of loans in years. The first one, it is mainly divided in 3 categories. The first one is loans outstanding for less than or equal to 1 year. The next one is loans outstanding for more than 1 year but less than 3 years, and the third one is loan outstanding for more than 3 years.
It is directly linked to closing balance.
Yes. So Dodo, what will be the annual compliances pertaining to this DPT-3 form? It will be for both the forms. It will be if it is audited financial statement or it is unaudited financial statement. It will be 30th June of the every year. The company needs to file. Penal provisions are provided under section 76A of the Act. The first one is if defaulted by the company, then the penal provisions are minimum 1 crore rupees or 2 times of the deposit accepted by the company, whichever is lower, and up to maximum up to 10 crore rupees. And if any officers of the company are defaulted in these penal provisions, then it will be up to the maximum 7 years. It has a criminal liability and fine not exceeding 25 lakhs, but which may extend to 2 crore rupees. This is also penal provision. As per section 164, clause 2 of subclause B states that no person who is or has been a director of the company which has failed to repay the deposit accepted by it or pay interest thereon on due date, and such failure continues for more than 1 year, the director shall not be eligible for reappointed or appointed for a director in that company for 5 years of the from the defaulted. So Bala sir, Manoj sir and Geetha ma'am, these are the FAQs which are continuously coming from the public. The first one is whether a nil DPT-3 form is required to be filed with the MCA.
Answer is no.
No nil return is required to be filed.
Okay.
You don't need to look at chapter 5, then you don't need to look at DPT-3 because the rules are framed pursuant to section 73, etc. of chapter 5. If you are not falling under chapter 5, you will just close the book.
It is simple concept. If you have allotment, you will file a return of allotment. If you have deposit or exempted deposit or anything to report in that DPT-3 as a deposit, then you have return of deposit.
Next one is whether acceptance of money from shareholders of the company will be considered as an exempted deposit.
No. It is not exempted deposit. It's a return of deposit.
It is a return
No,
of
it
deposit,
depends,
not
depends.
exempted deposit.
It is a return of deposit.
No, but again, I said facts do matter. If the shareholder is a company, it is exempted, certainly.
Correct,
Yeah.
correct. I know.
Yeah.
Yeah.
that
Concept
is
is
there.
there always.
Yeah.
People also need to ask right question, just to be clear here. So, and we have to be careful about. So what we are generally saying, you should also please match it with the facts, so that whenever you take a decision, it is accurate.
Yeah, take next.
The next one is detail of net worth as required in point 9 of the DPT-3 form. In case of the company has audited financial statement for the current financial, means how we have to fill this net worth.
So clear. So Geetha, you can proceed.
Yeah, but as per my understanding, net worth as per the latest audited balance sheet preceding the date of the return. So my triggering point always as a 31st March. Okay, so that as on 31st March, I cannot provide my audited financials. I mean, that preceding word, I always interpret as a previous year. It is 31st March 2022. That's what my understanding.
In case of a newly company incorporated, what should be the required to mention in net worth point, because there is a non-availability of previous financial year, or the company is a closing for the closing its financial year for the first time.
No, now I think in the new form, they are not asking for these details for exempted deposits. If I am
If
correct.
we have return of deposit, definitely they will ask this also. So in this case, if we take that interpretation of previous year, I mean as a 31st March 2022, in that cases we can fill nil. Definitely, I mean.
But is it asking for exempted deposits also? These
No,
details?
no, exempted deposit it is not asking.
Yeah.
Only for return of deposit. For
Return of-
example, if
Return
I
of
have-
deposit only it is asking, not for
Yeah.
exempted deposit.
correct.
If
If we have any loan from a shareholder who is not a director and which is not a company, in fact, so then definitely I need to fill it up.
Whether this can be put as a nil or it can be taken from the current years, unaudited.
Zero.
No,
Nil.
I think the-
Yeah, sorry. Continue.
If a company having only exempted deposits, whether such company required to file the DPT-3?
Yes.
If a company having only loan from the directors as on the 31st March, whether the company is required to file the DPT-3?
Of course, it is an
Yes,
exempted
it is.
deposit.
Yeah. See, whether you have a deposit exempted or not, the filing is actually required.
It is required to attach the auditor certificate in the form DPT-3.
Yeah, here actually the many are facing dilemma, because earlier it was asking for certificate from the statutory auditor. Now the statement, that declaration statement that the deposit, amount of deposit and the liquid asset, whatever mentioned in the form is correct. That is what exactly they used to certify earlier. And there is no radio button, separate radio button available for attaching statutory certificate or auditor certificate also. So then we are in the understanding that only the declaration affixing mere digital signature of auditor is sufficient for that.
Statutory auditor certificate is required for mere or
Already
mere
answered.
certification is sufficient.
Answer.
Is the amount received from a LLP exempt deposit?
If it is there is no exempt deposit concept here, because there is a separate column or else class available for money received from company to company. Okay, there is no such word used as a body corporate amount you received from the body corporate. So it is not exactly falling under exempted deposit. But if that LLP is a shareholder, then if it is a giving, it is not covered under exempted deposit exactly, but it is covered under return of deposit if that LLP is acting as a shareholder in the company.
The next FAQ is, what if the audited figures are different from the reported figures?
This Manoj need to answer for this question. As per my knowledge, revised DPT-3 is not required, because anyway, we all understand that it is based on the unaudited figures. At the same time, as on 31st March, what are all the things we are reporting under exempted deposit are almost freezed. There should not be any change in that.
There can be, Geetha. So I'll tell you, sometimes accounting treatment in your ledger may be different from what it has to be from a balance sheet point of view. And sometimes those numbers are, itemized again for the purposes of better presentation. And certainly that may not match at all times. The second thing is a lot of times you may do certain errors while reporting DPT-3. You may include certain credit debit note related transactions between you and your customer, etc., which may be reported as part of DPT rather than just reporting money which is received by the company through banking channels. So those kind of inconsistencies will always be there. In fact, audited figures, I don't know how one tallies audited figures with reported figures, because in most of the cases it is impossible even to have audited numbers tabulated accurately against these numbers. And nobody, actually the auditor's scope also is not to audit DPT-3 numbers per se. So they audit only from the perspective of reporting how it looks in the balance sheet. Obviously, for deposits, it's a different ball game, but for exempted deposits, it's a very, very different exercise altogether.
Is additional fees paid on DPT-3 gives way out the consequences under this chapter or section 450 of the Companies Act 2013? Geetha ma'am?
No, actually additional fee is only to upload your form, eligibility to upload your form. That's all. It is not
The
giving
additional fees is actually for the delayed period you pay some amount of the fees prescribed, but that does not absorb you from the non-compliances which has been actually persisting during the period.
And
So separate action will be taken for the non-compliances for the intervening period, and you will be actually penalized because it doesn't absolve any non-compliance. Because fees paying, because you're delayed, this is a delayed fees. That's all. But it is not setting right the non-compliance. Non-compliance still continue to be there, action will still be taken.
Okay, Niket.
Thanks.
That's all.
That's
Yes.
from my
Can we
side.
Yeah, we were knowing that questions will be more. Now, Mr. Bala, you can take the question from starting the first one.
Yeah, I'm
Okay.
coming there.
Because still the questions are coming, we need time. You are knowing that today the questions will be more. Mr. Bala, start from first question, huh? So
Yeah.
that there is no confusion.
Yeah, I'm coming there. Give me a minute.
Okay, I will start that first question. Can you please elaborate with the examples, the transaction which are covered under any other adjustment in form DPT-3? That was the first question.
I think that is debit credit note kind of a setup where you adjust that amount against something else. For example, any amount received from other company, any transaction where the amount has been finally agreed to be adjusted is covered.
Geetha,
Another true transaction I can see is maybe CC limits and all. Actually, see, these are all running accounts. We cannot how much amount repaid, how much amount addition is there. These things we cannot conclude properly in the running accounts, CC account, OD account, and all. There normally how we consider is closing balance minus opening balance. Whatever the amount left out, we will put it in the adjustment column. That is one thing. The second thing, where we have convertible securities for loan and all. So there also we cannot say exactly we repaid. Okay, because it is not repayment. It is adjusted towards, changing the entry from loan to capital. So in those cases also we are taking it as adjustments.
Okay, thank you. Next question is from Ms. Geetha. In case of unsecured loans or intercorporate loans, it is not possible to show the principal amount without the interest. So please guide us as to how we should make a disclosure in form DPT-3. Can I repeat? In case of unsecured loans or intercorporate loans, it is not possible to show the principal amount without interest. So guide us how we should make disclosure in form DPT-3.
I think, see, segregation is always possible because we are considering only the principal amount only. Otherwise, your opening balance and closing balances will be not matching. So while filing DPT-3, if you consider even interest portion, everything into the principal amount, so then it is reconciling to your opening and closing balances will be very difficult. So you have to stick to segregate and show it.
No, here it is always possible to segregate it because the principal amount without whatever the nature, even if you are working with the EMI, you know what is the principal amount. There's also a thing is that the segregation is required definitely, as Geetha puts it.
Yeah, you would like to take next question, Mr.
Yeah, I'll take.
Mr. Gaurav. Yeah.
Please guide us how to make the disclosure in the form that we have seen.
Yeah.
Okay.
By Gaurav.
Yeah. In case of the CCOD loans, since they are running accounts, there is no repayment until the account is actually closed. That is an additions within the limit of enhancement. Only the interest is debited. So how to arithmetically match the closing balance, opening balance plus additions minus repayment will not match the closing balance. Kindly guide on this, please.
I think it is already answered.
You just only answered this.
Directly we are taking closing balance minus opening balance. Whatever is the amount, we will put it in a.
Correct. That's right. Loan from the director are shown as the short-term borrowings. In an audited financials, such loans are actually in the form of the current account into bracket receipt of the payment as per the requirement of the company. And some of the loans are having age of more than 3 years. Every year interest is also provided. How to reconcile this?
I think the same strategy can be applied here also. The opening balance and the closing balance approach, where you do the balancing figures you put there in the repaid section.
We are getting a trouble while submitting the DPT form. It is showing an error that it has been already filed. Kindly, this we cannot answer because this is the system related questions between the V2 and V3, whatever is there. This I don't think we will be able to answer.
You just check actually, is there any open, already filled form for which SRN is generated? That is one idea I can give, but I don't know whether it is exactly works or not. But again, raising the complaint is one solution we can give.
Yeah, raising the complaint is only the solution which is possible. That's what I feel so. Share broker received deposit from the clients and transfer this amount to NSE, BSE stock exchanges, and sometime some amount is remain with the broker in a year end actually. Will it be falling under the exempted deposit and require reporting?
Is it towards a service or else it is towards deposit? Security.
No, it is client's money kept with the share broker pursuant to the SEBI regulations. As long as it is covering all those aspects and it is held in trust, it should be non-interest bearing, then it will be there. Otherwise, if it is received from a company and kept, then that eligibility can also be invoked.
We have advance from customers and suppliers done against them. There may be the closing credit balance or not. Do we require to disclose the advances received during the year and if sales are already made during the year? There are also opening balances and the billing is done in the current year. How to disclose billing, whether by way of other adjustments?
No, so just to gather the facts, advance from customer, supplies done against them. You need to follow FIFO method. Every advance you need to first settle that advance in your books, because if you are into a business where there is huge demand for your products, the customer, the distributor will obviously pay you in advance. So every PO has to be adjusted against the first advance first. So you just plot it month on month and then do a FIFO, and you will be able to have the opening balance as well as the closing balance readily available with you. And that way you will be able to work out the modalities of putting it on the form.
Manoj, 1 minute. This is going to be a very important thing in view that because when you are adjusting generally, companies do not give this invoices against which payment is made, but then it becomes difficult for customer to claim which amount is pending. In view, that become very important in case of limitation period, the course of action and recourse available. So when this return, you are telling this FIFO method you have to adjust. So if that is there, so it becomes crucial that where the default or failure happen, get crystallized with this adjustment.
Right. I think finance teams of companies need to work on it to plot as many details as possible of date of receipt of money into the bank account, then date of issuance of order by the customer. But in real life situation, customer can do a WhatsApp order also, right? Now things are changing very fast. And then the date of invoice, because ultimately you will adjust against an invoice of yours. And that is the most relevant aspect of that particular advance. So they can very well plot it and then adjust deposits in a FIFO method so that at the end of the day, you are able to achieve the balance amount. Because if you don't segregate advances through receipt in the bank account, then you will not be able to justify against 365-day norm. So to justify against that for a running account, you have to do all these activities. Sometimes what happens is, in fact, now any other adjustment will include certain debits which you will raise against them. But certainly in the opening or closing balance, you cannot add credit notes which you have issued them, because that's a normal business transaction. It's not a deposit transaction.
Yeah.
So
Do
for
we have
credit
to
for
file-
damaged products, credit for short receipt of products, etc., which you do a credit note kind of a setup, it's an additional, it's basically a refund in that sense.
Right.
But the first and foremost thing is amount received in the bank account, amount adjusted against supply, and amount adjusted against some other issues with the distributor or customer, which is accepted by the customer.
Right.
Do
Thanks.
we have to file the DPT-3 if there is an advance received from the customer of the sale of goods which is appropriated within 365 days? I think this we answered, I think so. In case of the security deposit given by the company to another company, again the supply of the goods and repayment is due in 5 years of giving the security deposit, will this require DPT-3?
Given by another company.
It will require DPT-3, but you need to be clear which exemption are you claiming or which exemption are we looking at. So this transaction has to be reported ideally under any amount received from any other company.
Okay.
Claim the best exemption as a company which you want to avail, which does not have limits. So for advance received against supply of goods is generally a deposit which is exempted, but only till 365 days. Whereas if it is an intercorporate advance received, obviously you would want to put it under any amount received from any other company rather than putting it here. So as a company, you have to claim the best exemption for yourself. So look for those. But the first threshold of exempted deposit reporting is to first ascertain whether it is in the nature of deposit, loan, or in any other form. One way of looking at it is all transactions which are exempted are generally in the nature of deposit. So those are reportable that way. And the other is if it is any amount received from, for example, any other company, whether it is something which is refundable in nature. So that will be parked under that particular heading.
We have accepted deposit from the public and filed a GLN 2 with the SRN is already approved. But while filing the DPT-3, the error that please provide valid SRN. GNL 2 filed V2 in the last year 2022. Again, it's a system related question.
What any comment or we can go ahead? We can exercise.
Anybody wants to share something on this?
That is only, sir, actually raising complaint itself is this one, because GNL2 whatever is there in V2 now it is not accepting in V3. It is again system glitch, technical glitch. They have to get a remedy in department itself.
By raising the complaint only.
Yes.
Yeah.
We have considered the RCFC for DPT-3, but whether any short-term borrowing needs to be reported in DPT-3 or not.
RC.
What is PCFC?
Rajan Javeri?
It's a packing credit facility.
What is
Okay. Packing credit facility.
Okay.
Okay.
Manoj, will you
It is
answer?
not a matter of short term, long term. It is a matter of whether it is in the nature of deposit, loan, or any other form, and whether you are availing any exemption. So, basis that you need to look at it if it is reportable, and whether it is you can still avail some best of the. For example, if it is an inter-corporate kind of a setup, you would prefer to put it under any amount received from any other company.
Loan taken from any NPSC can be shown under the head. Any amount received as a loan, the financial assistance from the public financial institution notified by the central government. Does NPSC consider a financial institution? Please clarify.
NBFC, you can consider under this thing, no company, company to company, this thing, because
Yes.
almost all NBFCs are companies. Okay.
Yes.
So they are not considered as public financial institutions under that, whatever the notification has given. So you can consider under company to company.
We have given a DPT-3 of the last year based on the unaccounted data of the loan received from the director. But after that, the amount is actually different after the audit. In this case, should the opening balance as per the financial DPT-3 of last year?
At least for this year purpose, because we are not, previous year, we are not on web form mode. Okay. So at least there is an option of changing as per the financials this year. But you be careful while filling next year, because it's a web form. There is a possibility to compare.
It will all be reconciled now.
Yeah.
So better, luckily this year you have got an extension also, better align these numbers with your auditors. So that next year and these numbers are reconciled. Now they will track this through web, B3 process.
Do we have to file the DPT-3 if there is an advance received from the customer of the sale of goods inappropriated within 3? I think this we answered, I think so. Do we need to report the outstanding amount received from the holding company for the services exported to them, which is billions on FIFO method? But is billable on FIFO method?
This falls under that 365 days thing, as we discussed about FIFO.
Before, yeah.
There is no specific exemption given for a subsidiary or holding company. All advances are considered same.
We are portfolio manager and AIF in the form of the private limited company. They received money from the investor. These transactions are within the SEBI regulation. Do we require to disclose the amounts in the DPT-3 under which head?
It is there, no? Last residual head they have given, no? AIF and all. Alternative investment funds, domestic venture capital fund. There is a category class 18.
Okay.
Whether loan by the private company from the HUF, which a director Karta is covered exempted deposit. I think you discussed this actually, HUF and Karta.
Yeah.
How to derive the aging of the loan of the overdraft facility accepted by the company, please advise.
OD.
Yeah, aging of loan for the OD facility accepted by the company.
Yeah, as we cannot, again, as we discussed earlier, only closing and opening balance only we were considering. Okay, so then normally every year, what is pertaining to that year opening balance, closing balance, we will consider there itself now in the adjustments. So aging normally it will, fit under within 1 year kind of thing. Now ODs are limited to 1 year only. It is every year renewable things. So very rare cases it is exceeding 1 year as per my knowledge.
Normally, OD is for the current to current year. It is actually renewable every year by the company. So it will fall
Right.
only 0 to 1 year. There will not be a aging requirement will come under this according to me. Please give the practical example of the amount held in trust. I think that you discussed elaborately actually.
Yeah,
You gave the example also. In the business of the paints and allied products, extra amount paid by the dealers to the company and the standing of the dealer's credit for more than 365 without appropriation of the goods will be treated as advance as per the definition of the deposits.
so what they are basically asking is, if I'm in a paint and allied product business and it's a running account, I give 100 rupees to the company, but only ask goods worth 80 rupees, whether that 20 rupees is not, since not appropriated, whether it has to be basically refunded as soon as you reach 364 days, or it may be kept to the credit of the company. As and when I want to basically deal with the company and adjust that 20 rupees, can I adjust that? That is precisely the question.
Yeah.
Now here we come to the concept of appropriation. So genuinely, there is a genuine business transaction which is backing this proposition. So insofar as appropriation can be evidenced against that first payment which you make of advance, against each advance, you will have to show as company, because you are at the receiving end of the compliance. You need to demonstrate that some appropriation against this transaction has happened. There is a proper dealer agreement. There is a genuine business transaction, etc. So full appropriation or full settlement is not what it seeks to achieve, but it seeks to basically achieve avoidance of contrivance and structuring of a nature where it is not a genuine business advance. So as long as there is an appropriation, there is a running account, etc., it should not be seen as an deemed deposit just because 20 rupees is now pending for settlement. And if it is a running account, why would you cut a check and pay them? Right. So they may come back. Today they are not coming back, but they may come back at some point in time and raise another order for that.
So,
Yeah.
so in this case, whatever amount left balance with the company will be roll over to the next year's supply, and that will not be treated as deposits for that year, right?
Yes, because if you don't do that, you are basically going against the concept of running account. So this is another very touchy topic, to be very honest. And now with aging and all, how this will be reported, because at the end of the day, you are compliant with the exemption. Okay, but you have not complied with how do you want to perceive it? So you are saying that I have appropriated against supply to this gentleman within 365 days, but not fully. And I am availing exemption on account of this being a running account. That's the logic.
That exactly in this case, I was talking that dealers, all the companies have dealers and that consumer products or kind of industry specific supporting products. This is the common practice and it's all over India and overseas, this kind of accounts are kept. And then the strategy, entire business strategy is required to be changed. The same thing I was talking, because it will run into crores of rupees over the period. Now, if we say not appropriate, there can be many amount. The amount can be bigger also. It can be 20-80 proportion also instead of 80-20. So it's a honestly ticklish issue going to be there. Yeah.
Is the loan from the shareholder taken by the private company for more than 3 years treated as a deposit, or it will be considered exempted deposit?
Come again, sir?
Is a
If the
loan
loan-
from the shareholder taken by a private company for more than 3 years treated as deposit, or will it considered under exempted deposit?
Loan from shareholders, it never considered as exempted deposit. It is again written and it is considered as deposit only, except that A2E, if you are falling under that June 5th notification, you are exempted from only compliance of 73 subsection 1 A clause A to E. That's all. All remaining thing you have to maintain.
Private company accepted the funds from the members of the company as per the complying the 3 conditions how to report the funds in DPT3 as they filed available for reporting. Funds received from members.
Return of deposit. Return of deposit.
Return of deposit.
We accepted deposit from the public and file the JNL2 whose SRN is approved. Oh, this we already seen it actually. This is a system problem again. Same question is getting repeated. In net worth calculation, whether the deferred tax assets can be considered in intangible assets.
I think it can be. I'm not an accounting expert, but I think it can.
Whether the company required to file the DPT3 return, even if there is no transaction to be disclosed.
We discussed.
We discuss, I think so. To keep continuously the presentation for the case of panel. No, okay, it's all right. This is the question. Exempted deposit, whether security deposit received from the tenant against the rent is required to be disclosed, because in the security deposit is not performance of the contract or supply of the goods or service by tenant.
Renting is a service, right?
Yeah, renting is a service. Actually.
Then we have to report under.
We will have to report. Do we have to file the DPT3? There is an advance received from the customer of the sale of goods which is appropriated within 360. I think we discussed this. Do we need to report transactions of loan from the bank, financial institutions, or from directors or company, whether the closing balance is nil, but there is an opening balance and also additions during the year?
You have to file.
You have to file this. Do we have to file the DPT3 when there is an advance received from the customer for the sale of goods appropriate? Yeah, this is again the same repeated question. Whether to file the DPT3, there was a loan on 1/4/22 and has been paid during the year end and the transaction as on 31/3/2023. There is no balance on 31/3/2023.
But during the year, there is a transaction because opening balance was there. There is a transaction during the year. So then we have.
You'll have to file. You'll have to file. A private limited company wanted to take the loan from foreign shareholders. Will it be treated as a deposit?
If it is as per FEMA regulations, okay, that is, there is a clause. Any amount received from foreign institutions or foreign shareholders, okay, if in line with FEMA regulations, subject to FEMA regulations, then it is an exempted deposit. Otherwise, it is treated as a deposit.
Can you please elaborate with the examples of the transaction which are covered? Any other adjustments in Form DPT3? I think you discussed this.
Yeah, the same.
Yeah.
Same question.
In constructions, a private company received advance from the customer, which is more than 365. Then can this be treated as the deposit or loan? And is the non-compliance of the section 73?
This is an important topic. This is an important topic. What it seeks to exempt is as advance accounted for in any manner whatsoever received in connection with consideration for an immovable property. Earlier it was consideration for property, now it is made consideration for immovable property. Under an agreement or arrangement. Immovable property is not defined, you will go to the General Clauses Act, read with Transfer Property Act, because without referring to Transfer Property Act, you cannot justify definition of immovable property. First and foremost thing is it has to be advance against consideration. It not has to be a booking about which is not part of the consideration. You know, it cannot be an amount which is basically held and there is no invoice raised, nothing raised, etc. So as long as it is an advance against a consideration, consideration is tabulated, advance is paid and in installments or whatsoever, that will be eligible here. Anything which is not in the nature of advance, you may not be able to take benefit as the company receiving it. So you have to receive it as an advance against consideration.
Do we have to file DPT3 if there is an advance received from the customer sale of goods? No, this I think repeated question again. Can you please elaborate about the loan stroke facility from the bank?
What to elaborate?
I don't know what is this question actually.
Whether you want to file DPT-3 that way they want. Miss Sakshi, what do you want?
Sakshi Agarwal, what exactly is in your mind on this question? Can you please elaborate about the loan facility from the bank? Can we hear from you? Okay, let her come back. Company has received the production linked subsidy. Then how should I consider?
So-
Subsidy, I think you discussed, I think so.
Yes, so they have not mentioned whether it is from government or who has basically funded that subsidy. But at the end of the day, if it is a genuine business subsidy given by government, if it is not refundable, it is given after completing each round of production, then obviously it will sit in your PL account.
Yeah,
It will not sit in your balance sheet.
generally
It is not
subsidy comes from the
reportable.
government actually. Yeah. If a loan is received from the NLB, is it intercorporate deposit or exempted?
Not
It's
both.
a wrong question, to be very honest.
Whether to file the DPT-3 if there was a loan from the director as on 1/4/22 or loan taken from the director during the financial year and has been repaid during the financial, there is no transaction and 31, there is no other transaction 31(3) under the head deposit. Because the transaction is there, opening balance is there, you have to file. That's what we discussed. How to interpret the word any amount? Is it include receive the amount through the issue of the securities?
Any amount which is refundable in nature is covered in the definition of deposit. That is why that exemption also has been carved out.
I don't know, somebody is actually asking, can you tell me about the MCA side, when it will start? How can we answer this question? Dipti?
We
Sir,
don't.
they're expecting from you that you will at least share few words on MCA V3. And
we
It's only,
cannot.
only the practicing people who are actually dealing, they can answer this.
Yeah. There's one question from Surya. Can a company issue unsecured non-convertible debenture to a company? Can it consider as exempted deposit?
intercompany transactions need not go to deposit rules at all.
Yeah.
But there is an interesting argument there, which I have in my mind. I mean, it haunts sometimes, that if you go for the receipt of deposit from members, some of whom may be company shareholders, their structure is that these are companies, then in those cases, whether you will comply with 73(2), or for companies you will really not comply, you will not create provision of security, etc., that you will deal separately, and the other one you will deal separately. So that's a structuring which can take place. But treating two set of shareholders differently will basically, structuring point of view, say this is possible, but it will sit against the concept of duties of director in this act. In the 1956 Act, you would have done a lot of things which did not really impair directors' personal, liability and other things. But today, with duties of director section in mind, which is very underrated, these kind of things which you do differently, if somebody opposes as a set of shareholders that you have not followed those processes for X, but for Y you have followed, etc., which is keeping their interest at risk, because some of the provisions for receipt of deposits from members are to strengthen and permit only subject to certain thresholds to be met. So therefore, you have to be very careful about deciding to do transactions, treating two set of shareholders very differently, just because there is an exemption given under the rules.
Yeah, Mr. Surya Prakash has raised the hand. Yeah, you can speak, please, Mr. Surya Prakash.
Yes, Surya.
Yeah. Thank you, madam, for giving an opportunity. So, in conclusion, when a company issued unsecured, non-convertible debentures to another company, it is an exempted deposit. Is my statement is right? Just I wanted to know.
Statement is right, but you have to comply with all of the provisions of the Act, insofar as debenture issue is concerned.
Section 73 to 76. Creation
No.
of debenture reserve.
70?
73 to 76.
No,
Creation of debenture reserve.
No. You need to comply with debenture issuance provisions.
Okay. Okay. The creation of debenture reserve, transferring.
You don't need to comply with 73, etc. because you
Okay.
are falling under any amount received from any other company criteria. But you need to basically comply with issuance of security provisions for debenture, unsecured debentures.
Okay. See, why I discuss this issue, some are stating that when a company issued amount to another company by way of ICDs, we have to look into that provision. But when a company issued debentures, and that too, these debentures are unsecured, non-convertible, it will be treated as a deposit. The another school of thought is also discussed. That's why I wanted to get it clarified, because some other are taking that there is already one specific class is there. That class states that company can issue only secured convertible debentures. If they come, then only it can be treated as exempted deposit. If not, it has to be treated as a deposit. There is a slight confusion. Their two school of thoughts are there.
No, so
Just
ideally,
wanted to.
insofar as
yes.
deposit rules are concerned,
Okay.
if the amount is received from any other company, even though it may be deposit by way of, if you read the definition of deposit, yet intercorporate deposit will not fall under the public deposit criteria, which is, met under 73. So intercorporate deposits are not seen as public deposits, and therefore they are out of the rigorous provisions of 73 to 76A.
Fine. In
And
conclusion,
at the
it is an exempted deposit. We can treat it this as an exempted deposit. Since the company, we can also take that umbrella that any form, they use the word any form of amount received by a company to another company, it includes by way of issue of debentures, then we can claim as a exempted deposit.
And you will put it under any amount received from any other company, because that is the exemption you want to avail.
Okay.
Rather than any
Surya
other
Prakash
exemption.
sir, each classes are independent. They are not subordinate to one to another. Okay, so there are wherever it is, see, for this, if you are issue compulsory convertible debentures, then you have exemption benefit in a two classes. Okay, so wherever, like, two different classes you have, wherever you find comfortable, you put it there. But there is no other classes available to claim that exemption. Only company to company is available. Why can't we use that benefit? Okay, that is, as you said, there are different school of thoughts. But since these are all independent classes, definitely we can go and cover under company to company.
The fact of the matter is that if you have an exemption list, and that's in normal day-to-day life also, you will see what is that the best thing to seek exemption under. You will obviously, for any intercorporate transaction, you would want to seek exemption under any amount received from any other company.
Thank you so much.
Loan from NBSC will be treated under the.
I think we covered that NBSC.
That we have covered. Okay.
Straightway go to Mr. Sumit question. Does any money received?
Does any money received from the company means all intercorporate deposit, loan, advance to subsidiary related companies without the interest? Can we take a shelter under this clause?
There's also we are covered.
Both are companies, we are covered.
Yeah. In the first case, if the public limited company could financial assistance from a bank in form bank guarantee, non-fund based of rupees 30 crores for 6 months. And in the second case, the company gets a bank guarantee of 45 crores for 2 years. In both the above mentioned cases, what will be the treatment of the DPT-3 as a bank guarantee is a contingent liability?
Sir, the very first word we have interpreted for deposit is any money receipt. In bank guarantee cases, are we meeting that requirement?
No, we are not at all. We are not at all. It is only undertaking. That's all.
So bank guarantee DPT-3 is not.
Yeah.
Is the answer. Yeah.
Kindly elaborate clause 4 of the amount received by the company from any other company. Is it cover advance of the services more than 365 days or other? This I think we discussed.
But while doing from now on, at least from this year on, while segregating these things, be careful, because this year you will consider under customer advance. Maybe next year you want to, because you're losing that exemption, so you want to show it under company to company. Then how system definitely capture you? You just think of and you just report it. That's it.
Whether the current account transaction in the method of the reimbursement between the group companies, usually interest-free in nature, we consider under money received from the company clause.
It can, yeah, okay. Next,
Unsecured loan from the director of HUF, and the HUF has been made a member of the allotting the shares. Whether it will cover under the clause of the loan from the directors, relatives or members, where it will be referring the DPT-3, whether exemption deposit or deposit clause.
I hope we have answered this, right?
I think HUF we discussed actually. Kindly share the PPT, it's okay. Company issues unsecured non-convertible debenture NPC company, can it be treated as an exempted deposit?
So company basically received against non-convertible. This we have answered. No change in position.
We have given DPT of last year of unaccounted financial. Later audited financial is the difference in this case. Opening balance DPT-3 should match the last year DPT of the audited financial. I think this also you discussed actually.
yeah, this
Amount paid from the director from the personal bank account for the company expenses accounted the loan from the director, whether it will be exempted deposit.
Again, the same concept, money received. But here actually, can we, Manoj, can we take little liberal way that actually on behalf of the company, this person spent?
Can you repeat the question? I'm just struggling to figure out question.
amount paid by director from his personal bank account
For company expenses.
for company's expenses
Accounted as a loan from a
as
director.
loan from director, whether it is exempted deposit.
No, if it is loan from director, then you have to basically see if you want to claim deposit exemption, it says any amount received from a person who at the time of receipt of the amount was a director of the company. Right? This amount is not even received by you. This amount will effectively be governed by 180, not even 185, maybe 188 also, because it's a reimbursement of expenditure. So in your books, you have treated it as a loan received from director, borrowing from.
Yes.
Yeah, that is right.
Since it is related question, I am, even.
But
that
at the end of the day, director should not give it out of borrowed funds for company benefits. That's totally prohibited.
Yeah, we are taking a declaration from the director saying that it is not from borrowed funds.
So this
But
is
whether-
well understood. It is well understood that, accounting adjustments cannot be seen as non-compliance. If you receive the money and then you pay versus if director pays and then claims from you, if you are able to prove it as a genuine transaction, if it is effectively loan in the nature of a book debt. It
The
a
amount
loan
is paid
nature of
by
a
the
book debt.
director, but since it is for the purpose of the company is repaying the director.
No, company is first making a entry in its book that we have received loan from director, not through banking channel, but or actually this should not be part of loan. It should have been part of payable to director under the reimbursement category, and then it should have been paid back to the director. It's in the nature of reimbursement because it's very short-term transaction of these natures, which should be at arm's length. If there is an arm's length markup also, that could have defended the transaction in a better way than simply declaring it as a loan.
But they have accounted as a loan.
Yes.
That's why the question is coming that it is a wrong, you can say wrongly
So in
accounted.
their books, whether amount is received or not, ultimately your books are saying that it is an amount received as loan. Matter ends there insofar as loan categorization is concerned. Now let us only look at the facts. Now your balance sheet said it is loan received from director. You need to have that declaration prior to that transaction being taken care of by the director.
But supposing we classify it as reimbursement amount payable to the director by way of reimbursement, will it be covered under unsecured loan, or it will not be considered?
No, reimbursements are treated very differently in normal course. Generally, reimbursements are not loans. That is well-established provision. But it depends on the facts of the case. Reimbursement cannot be in the nature of loan at the end of the day.
Manoj sir, my question in this case is, if the director made expenses from his credit card on a behalf of company, let's say for booking a flight, for travel purpose, for stay in for office meetings, in that case, how to treat this transaction in this kind of scenario?
No. If he is using his credit card and he is seeking reimbursement of expense for booking hotel, etc., for going for company purposes, it is not a loan transaction or deposit transaction. It is a ordinary business transaction undertook by the director for success of the company. These are very routine transactions.
So this does not have to be
reported. Or not, but you cannot do something which is in the nature of loan and then try to claim it to be a reimbursement of expense. That is what I'm trying to provide. These kind of transactions happens on day-to-day basis. You also do transactions through credit card for your clients. These are very genuine business transactions.
These
and
need not be reported in
limits
DPT-3. Can we say that these are not to be reported in DPT-3?
My view is, if it is a reimbursement of expenditure incurred by the director in ordinary course of business at arm's length, it is not in the nature of deposit or loan. Then it
Need
is
not be reported.
Genuine business transaction carried out by you pursuant to the Companies Act. You don't need to then refer to Chapter 5. But as soon as you yourself as a manager,
yourself is recognized as the loan, no? That is what you are recorded.
No, we can change the name.
No, it doesn't happen like
this.
Listen, Venkatesh. Ultimately, how this will pan out from a GST point of view, just look at it. Reimbursement of service and loan and interest, all of it is very differently treated. As long as your paper speaks for itself and it is a reimbursement of expense, it should not be an issue. But
so can we just,
companies know what they are doing. Fact of the matter is, companies know what they are doing. If they believe that it is a reimbursement of expense, a genuine reimbursement of expense in ordinary course of business, as per common parlance, there is no dispute around it. Otherwise, so even income tax department will question the transaction. Leave apart rules.
Can we classify it as a provision for expenses payable instead of unsecured loan? So will that solve the problem?
Creativity is not a subject matter of discussion here. What I'm trying to say is, as long as it is not a loan, it is not covered here.
Okay.
A reimbursement of expense in general business is not covered here.
And so DPT-3 need not be filed. DPT-3 need not be filed.
DPT-3 is not meant for reimbursement of expense report.
Yeah, reimbursement of expense, it is not required actually.
Okay, thank you.
But Manoj, generally, if the nature of the director job responsibility is a routine and frequent traveling and all those things, then the corporates may have some other options also, providing the corporate credit card so that this can be minimized there.
No, Sureshji, he is talking about a very routine kind of a matter where there is a small company where, even for example, two professionals may have a private limited company doing MCA related, filing related non-attestation work. They may go somewhere, pay from their credit card and claim from the company.
Yes.
They may go to Shastri Bhavan and claim that visit charges to the company and take reimbursement of that. It will be in the nature of reimbursement. No invoice, nothing will be raised in that sense.
Absolutely.
If the company has the security deposit for business purposes and the deposit kept more than 365 days, so please suggest whether that security deposit will cover deposit and how we report it.
No, security deposit is totally out of it.
Employee director of the company made expenses on behalf of the company and later on he asked for the reimbursement from the company against the bills on the name of the company. Can this amount be treated as a loan from the? No, because we discussed this is a reimbursement. Unsecured NCD is part of the deposit, but ICD is exempted. If the company has issued NCD to company, will it be exempted, considered under ICD?
We have dealt with it.
We have to mention the net worth of the previous financial, that's okay. What is the meaning of the amount appropriated? That also we have discussed. If the company is the business of interior design services and advance received in the company from the customer, that also I think you took it. In the case of the developer company, usually 12 months advance of the maintenance is actually collected, usually handed over to the flat happens 3 years later. So now it has exceeded 365 days. How I report?
Geetha, do you want to take that?
Sorry, I didn't get the question.
Now, in the case of the developer company, usually 12 months advance maintenance is actually collected. Usually handed over to the flat happens in the 3 years later. Now it has exceeded 365 days. How to report?
That is there, no, sir.
It is in clause, but the problem here is not maintenance. The problem here is the words used here as an advance towards consideration for providing future services in the form of a warranty or maintenance contract. So it has to be in form of a warranty or a maintenance contract in writing. If the period for providing such service does not exceed the period prevalent as per common business practice of 5 years from the date of acceptance of such service, whichever is less. So 5 years is the threshold. But if you see the builders, they keep it for several years. So that is where they will face some problem here.
But in here it is 3 years. So I think it is.
In this point, fee debtors show credit balance. So how to disclose in the DPT?
Sir, this question is of what time and who has questioned this? I'm not able to track.
No, it is at 12. This is actually.
So in this point, it doesn't understandable. What is this?
I don't know really.
The concerned questioner, please, can you?
Abhiravi?
So yes, sir. Yes,
Yeah.
sir. Good afternoon, sir.
Yeah.
Sir, in when looking at the balance sheet, the debtors balance, there are few debtors where the closing balance is showing as a credit balance. But later you told me that it has to be treated on a FIFO basis. So we can go on with that,
I
right?
get this question. So basically what she's asking is, if there is a credit balance, it is reportable or not. Credit balance could be, for example, you sold the goods. After that, the goods got damaged and you have to now raise a credit balance. One way is to pay them. In running account, it doesn't happen like that. You don't pay. You basically give a credit note. Okay, they don't raise another invoice or you don't raise anything else, but give a credit note, which at a later date, they will place on record and ask you to settle some of the portion of the new consideration which is flowing into the account and supply against that, so that your entire transaction is covered with that money which is left out with the company. This credit balance, you need to first see whether it was received as an advance for supply and balance is left. Is that the credit balance you're talking about, or is it in the course of business some new credit notes which have been issued by the company after adjusting the advance against supplies? Those credits can be avoided when reporting deposits because those are not transactions where advance is not adjusted. Advance adjusted, after that expired goods have come back, damaged goods have come back, you have issued credit note on good faith basis. Those are transactions out of purview of deposit rules.
Dipti, how much more time we have? Now it is already 1:20.
Yeah, just no 1:20, 10 minutes will take. I think we'll run it and we'll able to cover fast now.
Okay.
Still
You-
more question is there.
Yeah.
10 minutes more.
More than 50 questions are there, Dipti.
Let's see, but many HUAF, then that 365 coming.
But you should,
Okay,
you
we'll
should
see.
just run through and ask only those questions which you think are relevant now because most
Okay.
of them have been covered.
Okay. Industry loan, we have talked about it. Something on website, we cannot answer this. member, that also we talked about it. Sectoral allowance. Kindly explain sectoral allowance.
What do you mean by this? What do you want sectorial allowance explanation?
Yes, Pratiksha, what is sectoral allowance? You are asking the question. Pratiksha? Okay, let her come back.
Go ahead.
HUF, I think we answered.
Yeah.
Hello, am I audible?
Yeah. Yes.
Good afternoon, sir. Actually, I want to ask about the packaging credit facility where we avail the loan, the short-term duration loan, where the transaction gets started in the current year and ends in the current year only. So, how to report that transaction?
Geetha, you are on mute.
Addition repayment. During year transactions, you can add it.
Addition repayment. Okay. And another query is there where we avail the loan from the director. At the starting of the year, it was showing the credit balance, but afterwards, some of the transaction taken place. So at the end of the year, it turned into the debit nature. So how could we report that?
I think just now we have discussed this.
The same thing. Transaction happened during the year. Whatever happened, you have to report during the year.
Okay, okay. Fine.
No, she is talking about something else.
No. Debit balance, even
saying,
debit balance.
Saying earlier in the company, it was in credit balance. So director had given some money which was lying with the company. Suddenly, at the end of the day, something is receivable from the director.
Yes.
First, we need to decide whether it is a loan, etc. or not, because we are only talking about loan. We are not talking about reimbursements and other business transactions.
No, it was a loan facility actually.
You gave loan to the director?
No, we avail from the director.
Okay.
Then during the year, certain transactions took place. So the amount which was repayable now become the receivable.
That is what I'm saying. How it became receivable is subject matter of discussion here. That if it was loan is always payable, how can it be receivable?
It depends on the facts actually. It's many transactions what we have to check that. We cannot often give this answer, Manoj.
Earlier it was there under 73. So at the end of the year, it fall under 185.
It is a critical. We have to see the fact, then only we can comment.
Correct.
Okay, so based upon the nature of transaction, we
please.
that. Okay.
The only thing you are allowed to report and you have to report is loan received from directors, not transactions.
Okay. Thank you so much.
If amount is received as an advance received and as allowed by any sectoral regulator or in accordance with the direction of central or state government, then 365 days criteria does not apply. Is this correct?
Correct. There is no carving out anything for that exemption.
Okay. As amount received from directors or relatives already covered in related party disclosure note, whether we need to report separately?
Yes.
Requested to please take this question subsequently. At serial number 15 of the form, whether details is to be provided for line items where closing balance is nil. However, either of opening, addition, repaid, any other.
This we have discussed. We have to report.
If I don't know, shareholder is a director, I don't know whether interest-free loan received from existing foreign shareholders of the company will be treated. I think we have covered this. Aging of working capital loans. What is aging of company?
That we have discussed. OD limits it will generally be less than 1 year.
Okay, new company we can fill only share. Deposit from director who is also shareholder. How should we treat the loan from him?
Oh yeah, any one category you choose. Better to choose under director.
Exactly. Whether to file reported opening and repayment of any transaction under Rule 21C, which has no outstanding as on 31st March 23, and there are other transactions under Rule 21C due to which Form DPT-3 is applicable on company.
Other transaction means deposits, because she is telling exempted deposits not there.
whether to file reported opening and repayment of any transaction under Rule 21C, which has no outstanding as on 31st March 23, and there are other transactions under Rule 21C due, to which Form DPT-3 is applicable.
No. See what he's asking. If the closing balance is nil, transaction is there in the opening balance or during the year, whether it is required to be paid. Transaction is to be reported. No, that is what we said. Any transaction is reported irrespective of closing balance is nil.
In
Closing-
general, any column, opening, addition, deletion,
Any column, there is a
adjustments, closing.
transaction is there, it has to be
Yeah,
reported.
you just
There
file
is
it.
no question of closing balance in it, I don't have to report. No.
Yeah. How to bifurcate aging of loan if the company received money from directors at regular interval and paid to them also at regular interval?
He told no before method, first in, first out.
Yeah.
He already said that actually.
Due to TCS on sales booked delayed in Form 26 is as advance from customer may vary after DPT-3. I don't know.
Why? No. Why will it? I don't. So, first of all, whether advance received, how it will be subject to TDS? Is it advance for the only place where I so far as I know, generally is where immovable property is the subject matter of dispute. There sometimes people may want to deduct 1% TDS, TCS on advance. Otherwise, how is advance coming in?
No, advance will not come in this, I think, unless we know the full detail, we cannot answer this question. Under working capital loan, there must be a many entries during the year. So in the form, whether we need to give figures at the end of March 31st only, or we need to add reduced amount considered in each and every entry with the bank. Working capital loan means, are you talking about the OD facility? If that is the case, we discuss that.
We discussed that, yeah.
Yeah.
Working capital loan, OD.
Yeah. Suppose the company is in the business mutual fund AIF, and in the private course of the business, it enters in the various MF transaction. Does the company need to disclose about the transaction under 21C of the Form DPT-3?
This we have discussed.
Yeah.
Okay.
How to
Is-
show the interest portion in repayment schedule
Yeah,
of
correct.
loan.
Is
Seven.
auditor certificate is needed? Yes, we talk
It's
about
all we
this.
discussed straight
Yeah.
away. How to show the interest portion in the repayment schedule of loans. Shall we show it in the addition during the year, or payment should be shown only of principal?
If it is principal amount addition, repayment only we will consider. Interest portion we are not considering.
Okay, so only principal amount is to be shown.
If the company has accepted unsecured loan from the people who are rather shareholders, not director, will it be treated as a deposit? If vested, what treatment should be done?
Return of deposit.
If the OD account, the beginning of the year having a debit balance, under the closing credit, how to show the debit balance?
Form is accepting debit balance too.
Okay. What about the interest paid on the CC? Will it be counted total amount? This we think we discussed this. Money taken from the customer delivery of the home over a period of time. Will it be covered under the exempted
discussed
deposit?
this.
This discussed. Interest bearing unsecured loan taken by the private company from the partnership firm, who's also a shareholder, then whether it will be considered the deposit exempted category.
Discuss.
Rule 16 requires to file the Form DPT-3 to furnish information contained therein on 31st March that year. In view of this, whether to file the DPT-3 in zero as on 31st balance. This also we talked, if the transaction is there, you have to file it.
Yeah.
Yeah, closing balance is zero, that does not give you the sanctity not to
No,
file the form.
but basically, sir, what has changed from and why this question is coming again and again is earlier the MCA during their webinars, etc., had said that you need to report transactions as at 31st March. From now, it has changed from last year notification, it has changed to opening balance, additions, adjustments, and then closing balance.
Closing balance.
So now you need to basically see compliance for the year and then report. Even if any of the field is, requires a number to be filled in there, you are required to report now.
Will director current account balance in the private company will be treated as a loan from the director and comes under the exempted deposit.
This is typically an issue where transactions between director and company are not earmarked as to which category it relates to. The company needs to basically deal with each and every line item and try to understand the nature of transaction between the director and the company, and accordingly decide which of it is actually loan and whether declaration is in place or not.
If the company received share application money and the same has been allotted by way of the allotment of the share within the time period, does the company still needs to disclose the about share application under 21C in the form DPT-3?
So any amount which is refundable in nature is a deposit insofar as deposit rules are concerned. This is reportable if you have complied with it under exempted deposit.
Is advance under the long-term projects of supply of the capital good, is it received by the company? What compliances need to be done?
There is an exempted category available if you want to file the DPT exempted return.
See, I'll tell you one thing. Short term is less than 365 days. Long term is more than 365 days. That is first clarity, because capital goods is highlighted here separately, but intention is that anything more than 365 days will be seen as long-term project.
Now,
And it will not include immovable property. So you also need to see what kind of a transaction. Now in kind of a factory setup, if you see Duncan judgment of Supreme Court, which talks about what really constitute an immovable property in case of a slum sale kind of a transaction, where you're moving the entire factory to somebody else, right? There even machinery, etc. are subject matter of being called out as an immovable property. So that is one. But when you are setting up the factory, those are all treated as capital goods under D and not B, because those are not immovable property at the time of setting up the factory. But at the time of sale, those may be under immovable property. So when you are setting up the factory, you will certainly come under D, but at the time of selling, it will be a transaction under B.
I think we should stop here, right? 1:30 it is. And
Yeah,
still another 10, 12 question is there.
Not 10, 12, 40 questions are there. Number is appearing in front of me.
So that's why yeah, Mr. Anand Kumar, last question. And what we will do, wait, Mr. Anand, all the questions we will mail you and answer you. We have your mail ID. We will connect to the panelists, get their answers, and we will mail you. So we last, Niket, just keep in mind, last question we answered, and what unanswered question we have to answer them. Yeah, Mr. Anand Kumar, last chance, and we'll close the session.
Yes, Anand. I think he raised the hands, but he doesn't want to talk, it appears to me.
Yeah, I think in that case, thanks a lot, Mr. Manoj and Ms. Geetha. Wonderful session, lot of sharing of knowledge, experience. It was excellent interaction. If you can see, the participants were also answering themselves among themselves. This is the beauty of this program, that all participants, because the topic was so hot, the people were not allowed to speak the kind of questions. So we kept PPT small. Wonderful presentation, Niket, and Mr. Bala, your contribution. I'll again thanks Manoj and Ms. Geetha for your contribution. Thanks a lot for your time. Thanks again.
Thank you, sir. Thank you, everyone.
Excellent deliberation, Manoj and Geetha. Really, it's a knowledge addition. And another thing, as even at the closing time, we are around 200 and 130. Yeah. So that itself shows the importance of the topic.
Yes, sir.
This is again, yet another highest number of the people who attended, around 400. Thanks a lot. Thank you.
As a last word, it is a great initiative from Mehta and Mehta, and thank you for the opportunity given. And it was really a good learning for me too. Thank you.
Geetha, we have done so far more than 100 seminars. It is about 110th or 112th seminar so far.
Good, sir.
Thank you.
Thank you.
Good day. Good weekend.
Thank you.
Thanks a lot.
Thank you. Bye.